Good morning. My name is Stewart Dresner. I'm Chief Executive of Privacy Laws and Business, and I'm here to launch our 24th Annual International Conference here at St John's College, Cambridge. Our theme today, this year, is how to align privacy with your business strategy. Many businesses depend on using and monetizing personal data. Even if you're not in the personal data business as such, many companies use loyalty cards and geolocation services, and so personal data is becoming increasingly an important part of how companies do business today. And the question and the issue is how to demonstrate that your privacy policies and procedures are accountable to your stakeholders. You want to derive commercial benefit from the data, but you wish to recognise there are legal constraints. You wish to show that you are a credible custodian of personal data, and if you have a problem, you fix it. So how do you assess the risk to your business strategy if your data is lost or stolen? Now, accountability is a concept which was in the OECD guidelines, which were launched in 1981. And so that principle has been there for 30 years. But in fact, the accountability principle has been mentioned very rarely since then, until the accountability project was launched by Martin Abrahams and the Hunton and Williams team about 3 years ago. And they have been exploring this concept since then, working with national authorities and a group of large companies. And the challenge is to look at to what extent this is a robust concept and does it stand up to scrutiny. So that's why our first session today is looking at that concept, looking at both the positive aspects, and we'll also give time to some criticism and some comments, negative comments, where the critics feel it doesn't, or consider it doesn't, is not robust enough as a system of a supplement to the system of law. Now, these are the things I'll be covering in my introductory talk, and so we can see there the importance of looking at accountability to different audiences, and we have several other issues there. So the question is, how does your business strategy include privacy? Obviously, any business strategy has a wish to increase profits. In many cases these days, there is a wish to explore and demonstrate how a company is showing it's a good corporate citizen through a positive corporate social responsibility concept, and sometimes a team leading that effort. Also, of course, in recent years, there's been an important emphasis on a green strategy, which is partly to cut costs as energy costs go up, but also to show to employees and customers that the company really cares about cutting its carbon emissions. So many companies have a green strategy now. And all these things are to protect and sustain your reputation. The question is, where does privacy fit in with the hierarchy of worthwhile objectives that most organizations have? And when you're thinking about protecting and sustaining your reputation, you're thinking of not only your customers, but also your employees, and of course the media. Because in all these things, reputation is of absolute vital importance. So when we talk about accountability, we are talking about accountability to different audiences. And shareholders are one, of course. Stock market price is very important and where you are on that. Your customers, your employees, the media, and different regulators. Because the relevant regulators are here, not only the data protection authorities, and we have representatives from 10 different jurisdictions here at this conference, from Mexico in the west to Hong Kong in the east and several Europeans in the middle. But also in many countries, there are other regulators who work with privacy issues, such as in the UK Financial Services Authority, in Hong Kong, Insurance Regulator, and others. And working with regulators, having worked with privacy regulators for over 25 years, the fundamental aspect of this is that it's important to exchange experience and develop good working relationships. There are certainly benefits on both sides of developing mutual understanding. Companies can better understand regulators' aims and develop mutual respect. And there is a sense of interdependence. Regulators by themselves can't enforce the law entirely by themselves. They do need cooperation from companies and other stakeholders. And by working together with regulators, companies can make it more likely that although conflicts with data protection authorities may occur, they are at least more manageable. Because by meeting with them in various fora like this, both sides can build up a reservoir of goodwill. So if there's a problem, it's easier to overcome those problems. As a result of these meetings, data protection authorities obtain insights into the practical implications of proposed or actual decisions and better understand what companies wish to achieve. Privacy Laws and Business has been involved in organising roundtables with commissioners in many different countries for the last 10 years. And we've held them in many countries throughout Europe and involving regulators also from other regions. And we will carry on with this programme. So data protection authorities want to increase understanding of practical enforcement problems. And an example of this is data security, where sometimes the regulations are rather rigid. For example, when we had our roundtable in Poland, we found that the regulations stated that a password, a data security password, to be changed every 30 days. But by a process of discussion, both sides agreed changing the password every 30 days was not ideal because it was more likely that someone would put a sticky note next to the computer to remind them of that password. And by developing mutual understanding, there's an opportunity to reduce unnecessary bureaucracy. Accountability can also be built up by working together, by companies working to help develop the evolution of data protection law, an opportunity to make the rules clearer and more workable, and a frank discussion of rigid rules, and of the challenge is how to apply recognised principles to specific situations, such as the collection of consent for use of health data or use of sensitive data for the development in the context of clinical trials. So at the conference, we have regulators from these 10 different jurisdictions you can see on this slide, and it's an opportunity to meet them both in formal sessions and informally to test out your ideas of how accountability could work. But there's no doubt that there is, here at this conference, we have an opportunity to further develop how accountability can work and whether you think it's a concept which your organisation can benefit from. And of course, it's now being written into the revision of the EU directive. So the revision of the EU directive and a new text, draft text is expected in November, will contain several things that companies will like, such as the opportunity to engage in accountability and some of these sort of softer concepts, and other things that companies won't like, such as mandatory data breach notification. So there are many things that we're going to cover in this conference, and we look forward to an enjoyable and successful 3 days. Thank you.